Hello, I'm Amita and I will be presenting on duress under English law, focusing on whether Clumsy Corp can recover the sums paid to UK Dock Workers Union and greedy carriers. To start off, under English law, a contract may be voidable if it was entered into under duress, which is a pressure or threats that the law considers illegitimate. Title defines this as situations where a party's consent to a contract was obtained through improper pressure and the courts allowed such a party to resign the agreement. So these are three categories of duress under English law: duress to person, duress to goods, and economic duress. While physical threats and threats to property are recognized, the most relevant form of duress relating to Clumsy Corp's case is economic duress, which occurs when illegitimate economic pressure leaves a party with no realistic alternative but to comply. This was recognized in the Sibian and Sitaria case, where the courts acknowledged the existence of economic duress, although it wasn't found on the actual facts of the case. The case of Universal Tankship versus the International Transport Workers Federation is especially relevant to Clumsy's claim against the Dock Workers Union. In that case, a union threatened to blacklist a ship unless a payment was made. The House of Lords held that this constituted with economic duress because there was coercion of the will. The ship owner had no practical choice and the pressure was illegitimate, as the threat was not justified by any legal right. So similarly to Clumsy Corp's case, faced a sudden, unexpected demand from the Dock Workers Union for an additional £100,000 fee with the threat that they would otherwise refuse to unload Clumsy's products from Dystopia. Similar to Universal Tankship, Clumsy had no practical alternative because fulfilling the customer's offer was time sensitive and products were already en route. Importantly, Clumsy did protest. His conduct, he did protest and clearly reserved their rights. This is one of the key factors outlined in Pao-On versus Lau Yulong, where Lord Scavan listed 4 indicators for economic duress: whether there was protest, whether there was an alternative course of action, whether an independent advice was taken, and whether steps were taken to avoid the contract. In Clumsy's case, he did protest, had no viable alternative, and had to pay under the protest. An article that supports this is Pilkington and David Winterton. So in this case, they argue that even where there's a threatening act is lawful, it may still amount to duress if exercised unconsciously or in bad faith. Since the Dock Workers Union demands were later ruled unlawful, this reinforces the conclusion that their pressure was illegitimate and could constitute economic duress under English law. Based on these facts, the situation strongly resembles BNS Contracts versus Victor Green, where a threat to withhold performance unless wages were paid was held to be duress, and the innocent party was allowed to recover the sum. So, Clumsy Corp's second issue with greedy carriers is the situation also potentially falls under economic duress, because greedy carriers who had an ongoing 2-year contract with Clumsy Corp threatened to halt all deliveries to Wales unless Clumsy paid a surcharge of £500 per load. Clumsy again had no alternative carrier available on such short notice and agreed reluctantly, also reserving their rights. The scenario is comparable to the Atlantic Baron, where shipbuilders demanded an extra 10% mid-contract, and the threat to non-performance led to economic duress being recognized. However, in this case, rescission was barred due to the delay in bringing the claim. As Clumsy changed providers immediately after the contract ended, they avoided affirming the variation and may be entitled to recover the £150,000 surcharge. Another relevant case is DSDN Satsia versus Petroleum Geo, which emphasized that for economic duress to apply, there must be a lack of practical choice, illegitimate pressure, and the threat of a breach in contract. Greedy carriers' threat to stop performing under a valid contract without justification satisfies all these criteria. It wasn't just a bargain, It was a threat to breach an existing contract without legal basis, leaving Clumsy with no real alternative. To sum up my part, both union and greedy carriers exerted pressure that can likely be characterized as economic duress under English law. The threats were legitimate, Clumsy had no practical alternative, and they had to make payments under protest.
Thanks, Amrita. Hello everyone, my name is Adriana. Now that we've looked at what happened to Clumsy and the broader context of duress, I'll explain how English courts determine whether economic duress exists in the first place. While not all pressure in commercial contracts is unlawful, English law does step in when that pressure becomes coercive or illegitimate. This is where the doctrine of duress comes in, and if proven, it renders a contract voidable. While there are different categories of duress, my focus here will be economic duress and how courts assess it. The modern test for economic duress is best summarized in DSND Subsea Ltd and Petroleum Geoservices ASA, the year 2000s, where Justice Dyson laid down 3 key elements required for a successful claim. The first being the existence of illegitimate pressure, second being a lack of practical choice for the victim, and the third being that the pressure was a significant cause inducing the claimant to enter into the contract. This 3-part test draws on early authorities such as the Universe Sentinel in 1983, where Lord Scarman stated that there are 2 elements in the wrong of duress. The first being pressure amounting to compulsion of the will of the victim, and number 2, the illegitimacy of the pressure extended. Thus, courts are concerned not merely with the fact that pressure exists, as all contracts involve some degree of bargaining, but with whether that pressure is the type that law considers illegitimate. To determine illegitimacy, the courts assess both the nature of the pressure and the nature of the demand being supported by the pressure. In R. and Attorney General for England and Wales 2003, Lord Hoffman clarified the fact that the threat is lawful does not necessarily make the pressure legitimate. This means even the use of lawful threats such as to strike may amount to economic duress if used in bad faith or oppressively. To understand how the test operates in practice, let's consider the contrasting cases. In Atlas Express Ltd and CAFCO Importers and Distributors in 1989, the claimant delivery company refused to carry out their contractual obligations unless the defendant agreed to pay more. The defendant had no practical alternative due to commercial pressures, and the courts held that the variation was procured through duress. Similarly, in the Universe Sentinel, payments were extracted by the threat of industrial action. The House of Lords found that the pressure, while linked to a lawful act, was used illegitimately and constituted economic duress. Conversely, in CTN Cash and Carry Ltd and Gallagher in 1994, the claimant alleged duress when a supplier threatened to withdraw credit facilities. Although the threat had serious commercial consequences, it was lawful and not exercised in bad faith. The court declined to find economic duress, distinguishing between harsh negotiation and coercion. Another relevant case is Pao On and Lau Yu Long in 1980, where the Privy Council did not find duress because the pressure exerted was lawful and the claimants had options available. The case helped shape the factors courts now consider when determining whether consent was truly voluntary. Applying this legal framework to Clumsy situation provides useful guidance. In the case of greedy carriers, the demand for additional payment midway through the delivery contract under the threat of non-performance is closely analogous to Atlas Express. The pressure was likely illegitimate, and Clumsy had no realistic choice but to comply. This strongly supports the argument that the payment was made under economic duress. Concerning the union, the pressure arose from a threat to strike, an act that is lawful in many contexts. However, as seen in the Universe Sentinel, even a lawful act may constitute illegitimate pressure if used coercively and without justification. The question becomes whether the union acted in bad faith and whether Clumsy was left with no practical alternative. In both scenarios, if the court finds that the pressure applied was illegitimate, left Clumsy without real choice, and directly caused the payments to be made, then economic duress will be established. Consequently, the agreements may be held voidable, and Clumsy may be entitled to rescind them or recover the payments made, matters which will be further addressed in the next section on remedies. In summary, both the union and greedy carriers exerted pressure that under English law appears to meet under the threshold for economic duress. Clumsy protested and took timely steps to switch logistic partners, showing they did not affirm the modified terms. This strengthens their position for rescission or recovery. From a policy perspective, the courts are also concerned with protecting parties from economic coercion, especially when the stronger party exploits their position in bad faith. In light of these factors, Clumsy's case aligns with key precedents, and the payments are likely to be recoverable.
Hi everyone, I'm Jia Hao. Now that we see how economic duress can be established, I would like to talk about what Clumsy Court actually can do about it if duress is proven. Under English law, the main remedy is something called rescission. That basically means the contract or payment made under illegitimate pressure can be undone, or more formally that we say is set aside by the court. The goal is to put both parties back into the position they were in before the contract happened. Besides rescission, there's also restitution. This just means that if someone pay money or gave up a benefit because of illegitimate pressure, they should be able to get it back. It's important to note that rescission and restitution often go hand in hand. Rescission set aside the contract, and restitution ensure that no party unjustly benefit from it. For example, in the case Universe Steamship Inc. of Monrovia versus ITWF, in this case, the ship owner had to pay a union to avoid being blacklisted. The court says that was economic duress, and the money was recoverable. So, if Clumsy shows they were forced to pay under pressure, they can ask the court to cancel the payment and get their money back. And as Mindy Cheung-Wishart explained in her article, in defense of unjust factors, when a contract is set aside due to duress, restitution is based on the need to reverse the unfair pressure and undo unjust practice. Therefore, the law is trying to stop someone from keeping a benefit they got through coercion or exploitation. This principle is particularly significant in cases involving commercial pressure, where financial transactions are involved and the imbalance of bargaining power is evident. It ensures that fairness is restored in a situation where one party had no real choice but to comply. So, for Clumsy, restitution is especially relevant because we are talking about actual money paid under trade. Now, here's the important part. Restitution is not automatic. Even if duress is proven, the court might still say it's too late to undo the deal if one to the bar to restitution apply. The first bar is affirmation. If you continue with the contract after the pressure is gone, like keep paying or don't speak up, it can look like you have accepted the deal. That's what happened in the Atlantic Baron case. The innocent party continued to make payment under the revised terms for several months without protest, which the contract interpreted as affirmation. So, they couldn't undo the agreement. The second bar is delay. You have got to act quickly. If you wait too long before taking legal action, the court might say you lost your right to rescind. By Clumsy case, they protested right away and switched to a new provider as soon as they could. So, this shouldn't be a problem. The third bar is when restitution is impossible. That says the benefit can really be refunded. For example, goods have already been used or services are fully done. In that case, the court might not adopt rescission. But here, since we are just talking about money, which can easily be refunded, this bar doesn't apply. And finally, we have third-party rights. If cancelling the contract would hurt someone else, like a buyer or customer who rely on it, the court might refuse to grant rescission to protect them. But again, this isn't an issue for Clumsy because the payment were made directly to a dock worker union and greedy carriers, with no third party involved. It's also worth noting that court tend to assess the overall conduct of the parties when considering this bar. Clear and timely action by the injured party, as seen in Clumsy's response, strengthens the chance of getting an effective remedy. In Clumsy's case, Both payments, that the 10,000 to the dock workers union and the 15,000 to greedy carriers, were made under significant commercial pressure, with timely protests and no sign of affirmation. Since the benefit in both situations were pretty moderately and restitution is possible, Clumsy states a strong chance of recovering both sums under English law. Now, I will pass it to my next teammate. Thank you.
I'll begin the Malaysian law section by explaining the legal concepts of coercion, undue influence, and also economic duress under Malaysian contract law. These concepts are crucial in determining whether Clumsy Corp's consent was given freely or whether the payments they made can be recovered. But before I go into the legal definitions, let me briefly highlight the relevant facts. Clumsy Corp was pressured into making two separate payments. First, the UK Dock Workers Union refused to unload Clumsy's imports unless Clumsy paid a 100,000 annual unloading fee despite no such prior agreement. Second, Greedy Carriers Limited, already bound by an existing 2-year delivery contract, suddenly demanded an additional £500 per load. In both cases, Clumsy paid the sums under protest and explicitly reserved its rights. These events raised the questions of whether Clumsy's agreements to pay was truly voluntary or whether it was the result of improper pressure, possibly amounting to economic duress, coercion, or undue influence under Malaysian contract law. First, coercion is defined under Section 15 of the Contract Act 1950. It involves 1. Committing or threatening to commit any act forbidden by the Penal Code, or 2. Unlawfully detaining or threatening to detain property with the intent of forcing a party into a contract. However, the scope of coercion is very narrow. It applies only to threats that are criminal or unlawful under the Penal Code. For instance, threatening physical harm or illegal detention of property may qualify. But purely commercial or financial pressure, like what Clumsy experienced, often falls outside of this definition. This limitation has been acknowledged in a Malaysian academic commentary and also case law, like in the case between Tech One Trading versus Hydrotech Engineering and Chinambi Development versus Daikin Chu, where courts are cautious about extending Section 15 to cover economic pressure alone. Next, undue influence. Defined in Section 16 applies where one party is in a position to dominate the will of another and uses that position to gain an unfair advantage. This can occur in two ways. 1. Presumed undue influence based on special relationships like parent-child or lawyer-client, or 2. Actual undue influence, where there is no special relationship but there is clear evidence of manipulation or pressure. In clear commercial contracts, courts are generally reluctant to find undue influence unless there is a significant power imbalance and also unconscionable conduct. In Aidmin Sdn Bhd versus Chang Ching Chuan, the Federal Court rejected a claim of undue influence even though the plaintiff was in a financially weaker position. The court held that mere inequality of bargaining power is not enough without proof of domination or unfair conduct. So, applied to Clumsy Corp, where dealings were between commercial parties, undue influence is unlikely to apply. Finally, and most importantly, we turn to economic duress. While not found in the Contracts Act, economic duress is recognized under Malaysian common law through Section 3, Clause 1 of the Civil Act 1956, which allows the use of English law when no local statute applies. Economic duress occurs when a party applies illegitimate economic pressure that leaves the other party with no reasonable alternative but to agree. There are 4 core elements. The first is the presence of illegitimate pressure. Second is a lack of practical alternatives. The third is the causal link between the pressure and the agreement. And lastly, a protest of reservation of rights. The Malaysian High Court in Tasik Maju Sdn Bhd versus Chew Swee Kee acknowledged that economic duress can make a contract voidable, especially when the pressure deprives the party of free consent and the party clearly protested or objected. In Datuk Jaginder Singh versus Tara Rajaratnam, the court similarly recognized that consent obtained under commercial compulsion may invalidate an agreement. While the courts haven't yet formalized a test as strictly as English courts, Malaysian judges have accepted the concept where 1. The pressure was unlawful or in bad faith, and 2. The weaker party had no real alternative but did protest. To sum up, while coercion and undue influence under Malaysian law have limited application in commercial contexts, economic duress provides the strongest basis for Clumsy Corp to challenge the payments made. With that, I will now pass it to John, who will explain how these legal principles apply to Clumsy's situation.
Having now clarified the definitions of coercion, undue influence, and economic duress under Malaysian law, we can begin applying these principles to the claims made by Clumsy Corp. Let's start with the case involving the UK Dock Workers Union. Here, the union suddenly imposed an annual unloading fee of £100,000, an unexpected demand that left Clumsy Corp with little choice but to pay under protest just to get its goods unloaded. In terms of coercion under Section 15 of the Contracts Act 1950, the union's action don't appear to meet the statutory threshold. The refusal to upload cargo unless the fee was paid wasn't a criminal act, and no unlawful detention of goods took place. We can draw on the case of Chin Nambi Development Sdn Bhd v Thai Kim Chu, where the court made it clear that coercion requires threats of criminal acts or unlawful detention. Since the union's behavior amounted to commercial pressure, not criminal intimidation, coercion under Malaysian law doesn't apply. Next, we consider undue influence under Section 16. For this to apply, there must be a position of dominance or a relationship that creates dependency of trust. That wasn't the case here. The union wasn't in a fiduciary or trusted position over Clumsy Corp. This aligns with the ruling in HSBC v SYKT United Leong Enterprise and Anor, where the court held that financial pressure on its own isn't enough to show undue influence without a clear imbalance of power or manipulation. So, undue influence doesn't apply here either. However, the facts strongly support a claim of economic duress under common law. The union's demand of 100,000 fee was not backed by any prior agreement and imposed a significant financial burden on Clumsy Corp, who faced a real dilemma here: pay the fee or risk having its import stranded. The pressure was illegitimate, and Clumsy's protest, stating that it paid under protest and reserved its rights, shows that it didn't accept the new terms willingly. This is consistent with the principles affirmed in Bergamo Development M Sdn Bhd VECK Development Sdn Bhd and Anor, where the court held that consent extracted through duress is not freely given. Notably, since the court later ruled the union's action unlawful, this strengthens the argument that Clumsy is entitled to recover the sum under the doctrine of economic duress. Now, turning to the second dispute, Clumsy v Greedy Couriers Ltd, the facts are somewhat similar. Greedy Couriers had a pre-existing contractual obligation to transport Clumsy's goods. However, midway through, they imposed an extra £500 per load surcharge, which Clumsy paid, totaling $150,000 before the contract ended. On coercion, the situation is again outside the bounds of Section 15. There were no threats of violence or unlawful detention, just commercial pressure. The ruling in Nuri Asia is clear. Coercion requires more than financial leverage, and nothing in Greedy Couriers action meets that bar. As for undue influence here, there was no special relationship or dominance between the parties. They were merely in a typical commercial agreement. Again, the court in Ibrahim bin Musa v Bahari bin Nayan emphasized that financial strain without domination or manipulation isn't sufficient. So, undue influence is not applicable here either. However, as with the union case, the most promising avenue for Clumsy's claim lies in economic duress. Greedy Couriers was contractually obligated to deliver, yet imposed an additional terms after the fact. the pressure placed Clumsy in a bind, accept the surcharge or risk delivery failures. Given the lack of alternatives and the imbalance of bargaining power during contract performance, Clumsy may argue that its consent to pay extra was not genuine. If it can show that the protest or an attempt to preserve its rights, along with the absence of any contractual justification for the surcharge, a court could find that the payments were made under economic duress. So, in conclusion, the both cases, while statutory claims for coercion and undue influences fall under Malaysian law, economic duress emerges as the strongest basis for recovery. It shows how Malaysian courts are increasingly willing to recognize commercial pressure as legally actionable, especially when one party is backed into a corner with no real choice. Thank you.
Hi, I'm Loh Kian Yew, and today I will discuss the remedies available to Clumsy Court under Malaysian contract law. The primary remedies in such cases involve rescinding the contract and restoring the benefits. This remedy aims to restore the parties to their original position as if the disputed contract had never existed, or to compensate the harmed party for losses they suffered. If economic duress is proven, Clumsy Court has several remedies for both the UK Dock Workers Union and Greedy Carriers Limited. The first remedy will be rescinding the contract under Section 19 of the Contract Act 1950. As previously discussed, contracts entered without free consent, including those under economic duress, are voidable. In this case, Clumsy Court can choose to rescind the agreement, meaning they can effectively set them aside. Upon rescission of a voidable contract, the law states that any benefit obtained by either party must be given back. This is essential to ensure that no one party gains an unfair advantage over the other. Section 65 and 66 of Contract Act 1950 govern this principle of restitution. Section 65 states that if the innocent party chooses to rescind the agreement, he must restore any benefit that if the innocent party chooses to rescind the agreement, he must restore any benefit he received from the other party, or he must compensate the other party for the benefit. While Section 66 states that where the agreement is rescinded, the other party must also restore any benefit they receive from the innocent party or compensate the innocent party for the benefit. This can be seen in the case of Yong Mok Hin and United Malay States Sugar Industry, where the federal court applied the principle of restitution to ensure fairness between the parties upon rescission. Therefore, Clumsy Court would be entitled to recover the sums paid to the union and greedy carriers, which is £100,000 and £150,000. Beyond restitution, Clumsy Court may also be able to claim damages under Section 73 of the Contract Act 1950. This section deals with claims for compensation for loss or damage caused by a breach of contract or by certain other obligations. Section 73 states that when a person who has received money or anything by mistake or under coercion is bound to repay or return it. While the primary aim of rescission and restitution is to return the parties to their pre-contractual state. Section 73 allows for the recovery of money paid under coercion. The term coercion in Section 73 has been interpreted more broadly by the Malaysian courts than the narrow definition provided in Section 15. It encompasses situations where payments are made under illegitimate pressure, including economic duress, even if such pressure does not amount into criminal act. In the landmark case of Chin Nambi Development Sendian Berhad and Tai Kim Chu, the Supreme Court of Malaysia held that the word coercion in Section 73 is used in its ordinary and general sense, and not in the restricted sense defined in Section 15. Therefore, Clumsy Court can argue that the payments to the both union and greedy careers were made under coercion in the broader sense of Section 73, entitling them to recover these sums. In conclusion, Clumsy Court has strong legal grounds to recover the £100,000 and £150,000 paid to the union and Greedy Careers Limited. The presence of economic duress, coupled with clumsy clear protests, aligns well with Malaysian legal principle and precedent. It's a good idea to consider legal action because the potential of recovery is substantial, and it will help confront illegitimate business practices. Although litigation has its costs and its risks, Clumsy case is strong, particularly since the union's action were later found to be unlawful, which makes pursuing legal action a worthwhile option. So, this is the end of our presentation. Thank you for listening.